I have 10 a.m. I think that's him with a mask on. Mr. Fackler, is that you with a mask on? It is. Okay, I just wanted to make sure you were here. I'm sorry. You were in disguise. If the council members will please take their seats, we'll be getting started momentarily. Two, three, four, five, six, seven. We're missing a few, but have you seen Raul? Okay, we're going to get. Good morning. Welcome to the workshop on OGC legal memorandum. Let me kind of give you some idea of the flow of the meeting. I'm going to take a few minutes at the beginning to clarify some matters from the January 16th meeting. I'm going to get a little bit into security and procurement, and then I'm going to go through some questions myself, and then I'm going to go to the queue, and we will allot time on the queue based on the number of people in there. I want to give people as much time as I can and don't want to stop somebody if they're in the middle of a discussion as best I can. So if you know you're going to speak now, please get in the queue, and then I'll have some idea of how much time I'll be giving people. In addition, council members, in your chair are some documents that were obtained just recently through a public records request by one of the reporters on some documents from 2 or 3 years ago on the cemetery, the Hemming statue, etc., written by various attorneys in the Office of General Counsel. So those are in front of you, and I think Mary Ann has a few copies that are up here. If anyone needs them, you can get them. Okay. Yes, let's do introductions. Thank you. Let me start at my far left. Thank you, Mary Ann.
All right, good morning. Joe Carlucci, District 5.
Mike Gay, District 2.
Nick Howland, at-large, Group 3.
Randy White, District 12.
Ron Salem, Group 2 at large.
Kevin Carrico, District 4, good morning.
Michael Boylan, District 6, good morning.
Matt Carlucci, at-large, Group 4. Good morning to y'all.
Thank you all that are here today. I know this is kind of right before our 5th week, and I appreciate all that are here and understand those that could not make it. Let me just read something here to get us started. As we start this workshop, we are here not to litigate the removal of the monument, but the process used. I realize there are people who are not concerned with the process and just wanted the monument removed. The process is very important to me, and I think other members of the council, so that's why we are here today. First of all, I'd like to bring up Kim Taylor. Up to the podium, please. I asked Ms. Taylor to research the procurement process as well as the security process used in this process. And if you could briefly review those for us, Ms. Taylor.
Yes, sir. Good morning. Kim Taylor, Council Auditor. As far as there were 2 separate, I guess you would say, contracts. The first one was related to, even though there was no cost to the city, a contract was still required to be entered into to basically allow a construction onto city property. So as part of that, typically what you would see, there would have been an administrative award before that. That's kind of the trigger for the Office of General Counsel to enter into a contract. What we had asked about, we first asked for the administrative award because that's the typical, thing that we would look for. When we received it, it was dated January 3rd. So that was atypical. Normally, like I said, that would be before the contract was initiated. The contract itself does not actually have an effective date on it. We know that it occurred on December 27th. So after we received the administrative award we then asked, we went through that it appeared that it was not a proper purchase, that there were, because of the administrative award being dated after the fact of the construction company being on the property. We later then got a memo from Mr. Freeman, the Chief of Procurement, indicating that it was an improper purchase, and there's a process in the code that is laid out that basically says, and normally you're dealing with something where you're paying for services still, so it's a ratification process. Usually we would be copied on an improper, which we did receive the improper purchase memo. That was dated January 16th, and then it was signed by Ms. Bowling on the 17th. Basically, that process says, here's what happened. The procurement rules were not followed. We would like to rectify that, and we would like to still proceed forward and make this contract effective, basically. So that's what was done. That process was followed. It is laid out in 126.109 of the Procurement Code. I believe that's everything, Mr. Chairman. If there's anything else that I've missed that you think that's on the construction contract. On the security services, we have basically a blanket type of contract. We have a $3.3 million contract with First Coast Security Services. There are a list, and I can certainly provide that to everyone, under public buildings of all the public facilities that are covered. Springfield Park for the Confederate Monument is one of those locations. It's been under even last fiscal year, and even prior back to 2020, we've seen. But at least in the last fiscal year, there has been regular security provided at that location. So what we looked for, so from a contract standpoint, it falls under that agreement that's already been in place. On December 27th, there's just an uptick of about $903. Normally, one person staffs it, the security, from 10:30 in the morning till 6:30 at night, every day of the week. On the 27th, there were an additional 6 security officers for a total of 7, varying hours. Not all of them were 8 hours. But that contract appeared to be handled appropriately. As far as 2 days ago when we looked, it had not been paid yet. So I don't know if it's still under review by the department, which is the normal process. Usually I would say, within 30 days that invoice would be paid. So it's not been paid yet. But everything from a procurement standpoint was proper and falling under that contract.
So just to follow up, thank you, Ms. Taylor, for that. There are additional dollars the city is going to pay for security if that invoice is paid, as we suspect it will be. Is that correct?
That's correct, Council President.
So there were taxpayer dollars involved in the process if that invoice is paid.
Yes, sir. It appears it's $902.99 that, if paid, would be fall under that contract. Okay.
Council members, I'm going to continue my process. Ms. Taylor can come back up if you need her in the future. Thank you, Ms. Taylor.
Thank you.
I just want to make a couple comments about security, and I appreciate the sheriff being here today. My understanding, there was a private First Coast Security that was involved in this process. I have been told, and I'm going to ask the sheriff to come up in just a second, there was a police officer out there, one police officer that was out there at the site. That police officer was contracted by Acon Construction as a part of and I have seen, please come forward, Sheriff, and I've seen the document that the sheriff has. Basically, the form indicates he was there for a park project. There was no indication of what was going to be occurring at that park. And Sheriff, if you could just comment on that, number one, and number two, can you please tell us whether you were aware of the monument coming down? As the chief law enforcement officer of this county, and I'm interested in your comments, how you feel about it as well.
Mr. Chair, so, Council, I was not aware. I found out, I believe, the next day or maybe a day after that it had taken place. And I'll tell you this, we went to a system within the Sheriff's Office where a company has to apply for a police officer, and they'll put some information into that system, and we'll approve whether or not the police officer could go. So the form read this: event info, company Acon Construction, date 12/27/2023. Start and end time was 4:30 a.m. to 4:30 p.m. The location, 956 Hubbard Street. Number of officers, they asked for 1. Then it has the officer rate, which apparently is for them tier 3. Point of contact, Frank Anderson. Nature of request, and additional notes to pass along to officer. Security for construction project in a public park. So when the officer goes, he doesn't quite know the specifics of what's going on, but he knows he's going there for construction in a public park. In this situation, had I known what was going to take place, first I would have made sure that everything was in order, and then made sure we had enough, considering the volatile nature of what was happening, make sure we have enough, because you're really putting a young police officer out there by himself, and you put him at severe, in a risky position. And we never do that. We don't like to understaff. We like to make sure that someone's there. But I did not know until, like I said, until it was already complete.
Thank you, Sheriff. If you can stick around in case other council members have questions, that would be great.
Yes, sir.
Thank you.
Yeah.
Ms. Bowling, can you come forward for a minute? I clearly understand the desire of the administration to keep this somewhat under wraps. I have said publicly many times I did not know, and I was not offended that I did not know. I know some of my colleagues feel differently, but I understood that portion of it. There was one council member that was out there, and he has addressed how he found out, et cetera, so I'm not going to get into that. But not for the sheriff not to know that this was going on is deeply disturbing to me. Can you comment on that from the administration standpoint?
I can. Good morning, Council President and council members. We all recognize that this is a very emotional, heated issue. And so during the planning process, we had a number of discussions about what we might anticipate. And what we anticipated was that if this did become public, that there would likely be members that would come out to watch it. And we anticipated that most of those would be supporters, because we've seen here at City Hall on Friday the Take It Down people here on the steps. We've heard the comments that have been made at council meetings. So we anticipated that, again, if that became public, that some of those members would go to the park. That said, we anticipated that they would be peaceful supporters. We had told the contractors that we did not want that monument damaged in any way. And most people, or most contractors, aren't used to working with an audience. So our goal was to try to keep it, the stress levels down so that they could do their work, which was very, very a big ask. So we wanted a stress-free environment. So as you heard from the council auditor, we had the First Coast Security contract, and Mr. Darrell Joseph, head of Parks and Rec, was able to adjust some schedules to minimize the budget impact. So there were 4 security officers there surrounding the gate, and then we were aware that Acon was also going to hire an off-duty officer. One of the other things that we did was look at the proximity of the park to the District 1 substation, and it's about 3 miles. So we knew that, and they are very, they know that if they anticipate an incident or things seem to be heating up, that they would call 911. So our thought about notifying the police was that the police are very, very busy. And so, that's why security companies exist. That's why off-duty officers exist. In hindsight, I have all the respect in the world for the sheriff, so I would have called them.
Thank you. I appreciate your comments. I'll let the council and the public decide if that was the correct way to do it, but I appreciate your time.
Thank you.
Mr. Fackler, can you come forward, please? I hope you're feeling okay.
Yes, thank you, President Sale. One of my family members tested positive. The rest of us are negative and asymptomatic, and just in an abundance of caution, I have the mask to hide my identity.
Please, completely understand. Mr. Fackler, I'm not an attorney, that's been pointed out already, but can you tell me the obligation of you and your deputies that may come forward of being truthful in these comments? Is that an obligation for you as an attorney? Can you just enlighten me there?
I had not candidly thought about that, but I know that we've had discussions, and anytime in preparation for this, I said, look, you've got to be honest and tell the truth, and that's what we've all committed to do, whether we have that obligation under the Florida bar or otherwise. I would think we have an obligation to be truthful to our clients, and
okay.
So absolutely.
Thank you.
And that's absolutely our goal and our intention.
Okay. I appreciate that. First of all, I want to apologize for leaving that January 16th meeting early. I had a family obligation. But can you clarify for me if I had client attorney privilege on that document that you presented at that meeting?
I believe you did, and I'm new to having all these many clients that work through there. And so I believe you did, and I kept the contents of the memorandum confidential. I kept it within my team. I did not share the contents of it with anyone outside of my team. As I mentioned on that 16th, I did have a conversation with the mayor and some of her staff. We didn't talk about the specific contents of it, just how the process was going, because it was publicly known that that memo was coming out.
I'm going to get to the meeting that afternoon in just a minute. Because I thought I had privilege, and because I've worked with your staff, and I know when I ask for an opinion or an ordinance or whatever, your staff is very careful about not discussing anybody else. I sent you an email on 1/12 at 3:23 p.m. asking you for a meeting on Tuesday morning to review the opinion with me prior to 1 o'clock, so that I understood if there were changes in the opinion. I did not get a response from you. Can you tell me why?
I recall that email. My understanding was that if there are going to be changes in my advice, that to come see you to apprise you. And that we were going through that process. The advice didn't change. The process that we got to didn't change. So that's why I didn't think the invitation was called for in that case.
Okay, I sure wish you would have responded with that, because I never heard from you. And as you know, it was about 10 after 1 when I contacted your office, and I think I called you specifically to say, where is the opinion? And you had just sent it out around 10 after 1 for that 2 o'clock meeting.
Correct.
Okay.
Correct.
Can you tell me when you started working on this opinion process, either in meetings outside the government with other entities or outside parties, or actually writing the document? When did that process start?
Yes. And after Councilman Howland's question, I went back and kind of went through all my emails, went through my timesheets and my calendars to the best I can to create the process that we went through. So I believe the first date that I can find was a November 8th meeting that was, I believe, with Ms. Bowling on November 8th. Okay. Sometime before that, I know Mr. Rhodes had left me various files and so forth. So as I was getting up to speed and everything I was doing, I did review that file, and there was one on Confederate monuments that I reviewed.
Okay. On Tuesday the 16th, you indicated that you met with the mayor's office and on that Tuesday of the Rules Committee meeting. You said mayor's staff or mayor's office. I don't recall the exact terminology. Correct. Can you tell me specifically who you met with?
Certainly. It was Ms. Bowling and the mayor.
Okay. That was in her office?
No, it was in my office.
In your office?
They came to my office as I was working on the memo.
Okay. Now, you indicated in that meeting that you talked about timelines and did not discuss the opinion at all with them.
We talked about the process and my concerns about making sure that we get the right answer at the end of the day. But we did not talk about the specific
So you did
details.
talk about the opinion?
We did.
Okay. So it wasn't, because I had heard the word timelines, and that gave me the impression you did not discuss the opinion.
Yeah, we did not discuss the timeline. We did talk about generally whether the advice that I gave her previously was going to remain consistent, that she did have the authority and there was nothing to prevent her. That was the substance of that conversation.
So you obviously did not realize at that point that I had privilege on that document.
If I did and overstepped that, then that was an error. I didn't think I had breached that privilege because I was just talking about the advice that I'd given her, my other client, of whether that advice would stay the same.
Mr. Freckle, I hadn't even seen the document yet. I didn't see the document till the 16th, and you're discussing it with someone else on the 12th. I feel like you violated my privilege. And I think that's pretty clear. I think before you shared that thing with anybody, and I sent you an email asking you to do that. And your office, I can assure you, is very strict about that. I'm always asking what is Carico up to on this ordinance or that, and they're very strict about not discussing that. So I feel like my privilege was violated. Can you clarify for me the limits on a mayor, with your interpretation of the ordinance code and everything else, on raising private dollars to do work in this city?
Yeah, so this goes back to...
I know you might have answered part of this, but
Sure.
for today, because I have obviously introduced legislation that I think will prevent this going forward, but I want the council to understand exactly why I think that ordinance is important.
Sure. And if I could also comment on the legislation, I've had further discussions with my team, and we think there might be additional things to add, and we're having a follow-up meeting on Monday to ensure that we've addressed all your concerns and make sure your goal is achieved, that this doesn't happen again. And we're happy to meet with you and continue to work on that.
Please call me whenever you're ready to do that.
We'll have that meeting, and we'll follow up early next week.
Okay.
So generally, 106-441 allows the mayor to accept donations for any purpose unless limited by the 5 limitations in that provision. That's the general overlay. But of course, that's restricted by other provisions found in the code. For example, if there are requirements, either historic or it's inconsistent with something else, if it's not done consistent with procurement, all of those things are an overlay on it. So it's hard to talk about a general, what she can do, because each one would have to be analyzed and a limitation, see if there is a limitation to that general broad authority.
And keep in mind, I said a mayor. I'm not. This mayor has said she will never do this again. So let me put that down. But my ordinance is created for the future. Another mayor potentially doing this. But there is broad opportunity for a mayor to raise dollars to do work such as that. Is that correct?
That's correct. And what the saying, that kind of talking to the government ops people who are the experts in this is, the code giveth and the code taketh away. And so currently the code has given the mayor that authority under 106, and the code can taketh away.
Okay, thank you. One last area, and then I'm going to start moving to my colleagues. There were 4 documents that were obtained through a public records request about a week ago that this particular reporter had been waiting a couple of weeks to get these. They were written by, as I understand it, by Steve Rohan, Keely West, and as well as Mr. Teal. And they discuss the Hemming Monument at length and the differences between the Hemming Monument and the Springfield Park Monument. I went through all the specifics and such. Had you seen those before that they became public?
I had not.
Okay.
I had not. What I had in my file was the memo in the summer of 2023 from Mr. Teal that Mr. Rhodes had asked him to create. That's one. I was not aware of the others.
Have you read them?
I have.
And I have posted those on the city's website if anybody wants to look at those. Did they any way change or reshape your opinion?
No.
They did not.
No.
Okay. Okay. I am done. I have 3 people in the queue, so Mr. Howland, why don't you take about 15 minutes if you need it?
Will do. Thank you, Mr. President. I appreciate it. And Mr. Fackler, if you don't mind, stand up, please, sir. Before I begin my questions, I just want to reiterate one thing, and I've said it many times before. We do not have a monument crisis. We have an abuse of power crisis here. My inquiries and those of my colleagues are about the process, in particular about whether executive overreach occurred, how much influence this mayor has wielded over the consolidated government's new general counsel in the process, and whether the balance of our local government's distributed power has been disturbed by the actions and the subsequent corrections of December 27th. We're the policymaking body, and it's our duty to look into this. Abuses of power unchecked can lead to abuses of power again, not only within this administration, but perhaps within the next. Couched in business terms, this is akin to the board of directors exploring whether the company's CEO and general counsel took action that exceeded the delegated levels of authorities that the board, as representatives of the shareholders, granted to them. The 19 of us are representatives of voters. Every voter in Jacksonville, in fact, is represented by 6 of us. So we're the policymakers, and we're the closest body of government to the people. As the council president told the press yesterday, it's our duty to explore these issues. So I'll get that. With that, I'll get into my inquiry here. Mr. Fackler, we only had 45 minutes to look at your 26-page opinion last week, January 16th. And during that time, I asked a few questions. Most of them were about nuances and changes from that January 6th, from the original December opinion that you briefed us on January 2nd to the January 16th opinion. Action News Jax and the Times-Union kind of laid out a timeline nicely, and I want to reiterate that. There was a June 2020 opinion under General Counsel Gabriel, a July 2023 opinion under General Counsel Rhodes, and decades of precedent, all saying that that monument was protected and that a COA was required because it was a contributing structure to the Springfield Historic District. Then on December 27th, in the memo you sent us and then reiterated in front of rules on January 2nd, you said it's not protected, that no COA is needed because it's not a contributing structure. And then 2 weeks later on January 16th, the opinion we got 45 minutes before, you said it is a contributing structure, but now we're focused on actions that mean a COA is not required, and only certain actions require a COA. You specifically said this was not one because it was not demolition of a building. And I want to take a quote directly out of your opinion. The action performed on the monument was limited to removal of the 2 statues installed within the overall structure. It was not a demolition of a building, since a monument is not a building. Can you understand how that kind of looks to the general public, that it's kind of like you're now searching to justify an answer?
I certainly can.
Okay.
Absolutely.
Well, then let's tease that out. On January 2nd, you specifically said that the really neat Clutho-designed balustrades and bridges in the Hogan's Creek Improvement District were protected because they were within the Hogan's Creek Improvement District, and that was a contributing structure. Under your January 16th opinion, since they're not buildings, it appears that they're not protected. Is that correct?
A couple of things, if I can. The Hogan's Creek Improvement is a specifically listed contributing structure.
Mm-hmm.
And so it is entitled to certain protections different than those that aren't specifically listed contributing structures. In my opinion remains the Confederate monument in the 1991 legislation was not a specifically listed contributing structure. So there is a distinction there that the Hogan's Creek improvements are specifically listed. And so I'm entitled to protections by being specifically listed and being a property within the historic district, which was the analysis that my December 27th memo and leading up to that, that's where the error lie. And I admit to that error, and I believe it was my hubris in thinking that I could read the code without talking to my qualified people. And I relied on a bill summary that said the only thing that's protected, and the bill summary said, I got the language because I remember reading it and thought, it's just contributing structures. And the bill language says that it's after declaration of a district, design guidelines shall be imposed and COA is required for any alteration, addition, or demolition that would substantially affect exterior appearance of a designated contributing structure in the district. That's what I relied on. I did not consult the people who work in this area, and it was my error in relying on that bill summary instead of digging into the code and so forth.
Okay, so the balustrades and bridges no longer protected?
No, they are specifically listed contributing structure. The Hogan's Creek improvement is on Exhibit B, the contributing structure.
Okay. All right. Well, then let's move to what also changed between the January 2nd opinion and 16th opinion, because it's not just real structures which could be now at risk, but it's a lot of language. The word alteration was used throughout your January 16th opinion, not in your January 2nd. You brought up Section 320 in your January 16th opinion, but not in your January 2nd. You really built your opinion around the list of activities that require COA in your January 16th opinion, but not your January 2nd. And again, your argument is that it was not demolition of a building, so it does not require a COA. Can you confirm that all of those are legitimate changes from January 2nd to January 16th?
I can.
Okay. It's interesting. I said last week that this is legal gymnastics. Now I think it's legal yoga. I'd really like to know how all of this transpired. If I can, I would like to bring up Mr. Teal. Thank you, Mr. Fackler.
Mr. President, Jason Teal, Office of General Counsel.
Thank you, Mr. Teal, and through the President. Okay, great. Mr. Teal, I mentioned earlier the 2020 memo for GC Gabriel and the 2023 memo for acting GC Rhodes. You wrote those memos, correct?
My understanding through the President to Councilmember Howland, if the memo that you're talking about as far as I did write one of the memos from 2020. I think that there were a total of 4. One of them was written by Steve Durden, one of them was written by Keely West, and actually I think I might have authored 2 of them. And so if it's the one that I think you're referencing that has been talked about, then that yes, I wrote that particular memo.
Okay, thank you.
As well as the one for Mr. Rhodes.
And can you please walk me through your involvement in preparation of the Council President's the January 16th opinion that was prepared at the Council President's request? Really, I'm concerned again about what happened between January 2nd and January 16th. So if you could walk me through your involvement.
Sure. So I was not involved at all in the initial draft memo that precipitated the December 27th actions at Springfield Park. And so as far as how that process evolved, I cannot weigh in on that. I was brought in after, I think, the initial Rules Committee meeting that Mr. Fackler wanted to bring his senior staff together. So it was myself, Lasikia Hodges, John Sawyer, and Craig Feeser met with Mr. Fackler to talk over, and I believe it was in response to the Council President's request that his draft opinion be finalized at the Rules Committee meeting. And so that was my first, I guess, involvement in terms of putting, the modifications, if you will, between the initial memo and the final work product. So that initial meeting occurred. We discussed, the different aspects of the memo itself, from the procurement piece to the in-kind donation gift piece, and then the historic preservation piece, and then it went through. I think Mr. Fieser was charged with kind of doing a redraft of that to react to the overall strategy, I guess, if you will, for the final work product. And then a draft was circulated, which we all reviewed, and ultimately it ended up being the final work product that was submitted at the second Rules Committee meeting.
Okay, thank you, sir. Last week, Mr. Fackler said that he brought all of his deputy GCs together. I think it was on January 10th, Wednesday, the day after that big windstorm, and he said that there was a consensus reached there, and I believe that consensus must have been whatever is now in the January 16th opinion. So when did your opinion change, your personal opinion change, based on legal precedent and in the past, about believing for the last 10 years that this is protected, and now suddenly it's not protected?
Through the President, Councilmember Howland, it may be too strong to say that my opinion changed, but because remember, I'm in my 24th year with the General Counsel's office. Part of my time was the staff attorney for the Historic Preservation Commission. And I distinctly remember an application that was filed for one of the other buildings at, it was then known as Confederate Park, came in for a certificate of appropriateness. So I know that the city had been treating, the structures within Confederate Park as being protected. Obviously I have a long history with all of the memos and everything, at least through the last 4 years, 3.5 years, of taking the position that, look, I don't arrive at that decision lightly. It's based upon a lot of different things that we do when we analyze issues like this, which is what's been the past precedent, what's the language that's in the code, how has it been applied, what's the intent, what kind of precedent will be established, going forward. Based upon the direction that's taken in any given opinion. I don't want to say that my opinion has changed on this, but what I think is important to recognize here is that you have a general counsel that's established in the charter as being the final arbiter of these types of disputes. So what I fully embrace is the role of the general counsel in terms of what he has the legal authority to do. There's jokes all over the place about you get 10 lawyers around a table, you're going to get 10 different opinions. So lawyers differ in opinion. I called the calls that I did based upon my personal research. I did it for Jason Gabriel, I did it for Bob Rhodes, and then I assisted most recently with General Counsel Fackler. So, I guess I don't know if that answers your question, but I don't think I can say that my opinion changed, so I can't say that when it did.
Okay. You mentioned 10 different opinions from 10 different lawyers. What I'm concerned about here is 10 different opinions from the same lawyer. And actually, if you look at Mr. Fackler, the council president asked Mr. Fackler about the meeting on January 12th with the mayor, and it so happened I asked him that last week. And I said, did you share the opinion that you were writing for the council president with the mayor? And he said, I did not. And I said, did you share it verbally? And he said, yes, with the mayor's administration. And I asked, did that change your opinion? And he said, no. Just now he told the council president that part of the discussion that he had with the mayor and Ms. Bowling on January 12th was concerned about getting the right answer at the end of the day, and that he did talk about contents. Did you have a conversation with Mr. Fackler about his meeting with the mayor on January 12th?
So let me, through the president, preface all of this by saying that I have never been in any meetings with the mayor and Mr. Fackler to discuss this issue. So, I preface that by saying some of this is speculation based upon, conversations that I had. But to your specific question, the only knowledge that I have regarding any meeting, specifically with Mr. Fackler and the mayor, was in the process of kind of coming to the final evolution of the memo that got circulated. At that initial meeting, after dates, it was the day after the big storm and all city business got canceled. We all met internally, and as I mentioned, we came to some conclusions as far as direction goes. The direction at that point was that, as far as the historic goes, was that that it was contained within the Springfield district, that it was protected under the Chapter 307 of the Ordinance Code, and that the activities did require a certificate of appropriateness. It was based upon, kind of going through all of the, the things that I mentioned, the precedent and all of that stuff. So the direction at that point was to modify the memo, but, to pay attention to kind of how things were phrased or how, it was going to be worded in order to be able to, kind of draw some continuity between the initial memo and the final memo. So Mr. Fieser was tasked with kind of doing a redraft of that. At some point, I think it was the Friday, Mr. Fackler called me into his office and said, I think his words were, I got out of a difficult conversation with the mayor. We need to take another look at, the outcome of this memo. And so at that point in time, we went back to the original ordinance, looked at the language that was in the original ordinance as far as what activities were specifically enumerated in there for requiring a COA, because this is getting deep into the weeds on this stuff, but when a historic district is designated, part of the adoption legislation has to contain a list of what actions would require a COA for structures in that district. So that was where the focus was looking at those listed actions that required a COA, and the specific language says demolition of a historic building or alteration of a historic building. And so then, it went into what's the definition of a building? Is the monument really a building? Because, the code kind of intersperses building and structure in a lot of ways. And so, that's really and then I actually ended up redrafting the historic piece of the memo to kind of conform with the direction that while it was covered under Chapter 307, the actual work that was undertaken did not meet that definition of demolition or alteration of a historic building.
And all that happened after this, Mr. Fackler told you about his conversation with the mayor. That was all that I got out of it, and then I stopped listening at that point. Can you repeat what Mr. Fackler told you about his conversation with the mayor?
Yeah, so I was in a meeting with two other attorneys, and he popped his head into the office and said, "Hey, when you get a minute, can you stop by?" I ended that meeting and went to see him, and it was basically that he said that I just had a difficult conversation with the mayor. Now, mayor's staff, I don't know, but and that was what prompted the conversation about taking another look at how we were going to present it or what we were going to present in the final memo.
Wow. Thank you, Mr. Teal. I appreciate that, and that's a lot to digest, particularly after you said that Mr. Fackler told you it was a difficult conversation with the mayor, how you had to look at all that definitions and specific activities in order to get to an opinion that sounds to me, get to a legal opinion that sounds to me was trying to justify an answer. If there was ever any doubt that this opinion was written to justify a decision that was already made, I think that puts those doubts to rest. Mr. Council President, I'm turning over to you. Mr. Teal, thank you so much. Thanks for your 24 years of service to our city as well.
Thank you. I'm going to continue going down the queue. Mr. Gay, you're next. Mr. Gay, if you'll give me a second, I did not mention public comment. If we do have time at the end, we will take public comment, but it just depends on the time we need. Thank you. Mr. Gay?
Thank you, Mr. President. Can I have Mr. Fackler come back up? Just in general, to set the stage here, my position and point on this is definitely the way this situation was handled and the procedure and the protocol that was taking place. I'm a big proponent of making sure the law's followed and everything's in order. I myself I don't have a dog in this fight. I'm Native American, and I've got other issues I could be stomping the ground about. But on this issue, I feel like that the protocol we need to get answers on. Do you recall on December 27th, I sent you an email with questions, and then you responded back to me on 12/28, and the email I sent to you was to you, and when you responded back, there was CC on that. Is there a reason why you copied somebody else on your responses back to me?
Through the chair, to Mr. Gay, I don't recall whom I CC'd. If it was someone in my office, I often do that to keep them all apprised of our interactions with the mayor's office. If it was someone else, I'm happy to answer why I copied that particular person, but I don't recall.
It was Craig, is it?
Feeser?
Feeser?
Yes, he's someone in my office who assisted me with the memo, so I wanted to keep him in the loop of questions that we were getting about the memo.
You know, I worked through a lot of the procurement legislation and the OGC at that time, and there's been some ethics things different things that I've looked at and worked through, and it's been very delicately handled that they let me know if somebody else was going to be included in conversation, and I was kind of surprised on what was taking place, because it didn't seem to be the normal protocol that was taking place. So you responded back on 28, and I responded or sent some more information requests to you on 12/29. And as of today, I've still not received a response on that.
I apologize, Mr. Gay. I do not, as I stand here, recall getting that follow-up email. I don't have a reason why I did not respond to your 12/29 email.
Okay. The email that I sent that it had in there about the first email where I said about the permitting regulation, and you said you got with Public Works, and Public Works said you didn't need a permit. Well, the Public Works is not the building official. The building official has the authority to say what is permitted and what's not needed for permitting. So, I mean, there's definitely a step that's missed there. One of the big questions that I asked you was who paid for the statue and the ownership of it. Who owns the statue?
The answer to that, through the chair to Mr. Gay, the answer is the city of Jacksonville. It was a donative gift in 1915, I believe. And I apologize, and I believe it might be coming back to me. A lot of your questions became wrapped up in what I perceived as the council's questions. So I made the incorrect assumption that the memo would address your email concerns. I believe, and not a good reason for not answering you, but I believe that was the rationale.
When a developer, give you a scenario, when a developer puts in a water line for JEA, they at the end have to give deed it over to JEA. So was this statue basically placed for for us to be the caretaker of it, or was it deeded over to the city of Jacksonville?
Through the chair to Councilman Gay, I don't believe there was a deed issue for personal property. I believe in 1915 it was a gift, and we did some research on the ownership of it, and it does indicate that the city of Jacksonville is the owner of it, whether a deed is required for personal property such as the monument. I don't believe there was a deed, or if there was a deed or a bill of sale, I don't believe that that was found in our research.
Okay, I'll come back to that, those items here in a second. The contract that was issued, there was a no dollar amount contract issued from procurement to the contractor?
Through the chair to Mr. Gay, the way the contract worked is the city, had a contract with ACON, and it outlined the scope of services and the typical things that we have in a contract. ACON then had a contract with 904 Forward for the payment of the services that ACON performed for the city.
And that the services was to remove, alter, demolish, whatever you want to call it, it was to remove the statue.
That's correct. That's
okay.
Correct.
So ACON, here's where there's some problem. 904 Forward is not the owner of the statue. By state law, 904 Forward cannot contract construction work with a contractor and not be the owner. The owner, City of Jacksonville, or whoever donated it, is still the owner of that. That points toward that there is a violation, and ACON, as a licensed general contractor, should know and is supposed to know you don't accept contracts from an unlicensed or not an unlicensed contractor or a entity that's not the owner. So there's big problems there. And the other point that I brought out to you was there was not a notice of commencement filed. Now, I just heard that what was requested from the police sheriff's office to have an officer out there was for a construction project in the park from the contractor. So it's identifying that there's construction work going on, no permits are being pulled, and you've got notice of commencements that's not filed. And when the notice of commencement is filed, that means the owner has to sign off on it, and it becomes public record at the courthouse. That being that when whoever is hired on that project is then responsible, that the owner is made aware that subcontracts are being issued on that, and that if we have to make sure that they're paid. As a city, we had a zero contract, but we are still liable to make sure that Coker Crane and all these other Sunbelts and all these people are paid on the job. So we do have financial responsibility and liability that was omitted. And it just seems to be a continual circumvention going on here that doesn't follow the rule of law. And construction law is clear. I've talked to many contractors that do demolition, house movers, whatever you want to call it. And that, yes, before a structure is touched, and I know firsthand that the city does an environmental study to make sure there's no asbestos, nothing that's there before a structure is removed, altered, demolition, whatever you want to call it. You had countless number of people out there around this park that, who knows, if airborne asbestos took off, then we would be responsible again. So there's a lot of negligence that's taking place here in haste, and we didn't follow the full protocol. One of the other questions that I had with you was the fact that was there state statutes, and you referred back to me that pending legislation. I wasn't talking about pending. Per Florida statutes 806.13 and 806.135, it clearly deals with historic property. And it says that Historic property means any building, structure, site, object that has been officially designated by historic buildings, historic structure, historic site, or historic object through a federal, state, or local designation program. B, memorial means a plaque, a statue, specific says statue, marker, flag, banner, religious symbol, painting, seal, or display that is constructed and located with the intent of being permanently displayed, perpetually maintained, and is dedicated to a historic person, entity, or an event or a series of events and honors the recounts of military service of any past, present United States Armed Forces military personnel or the past, present public service of a resident of a geographical area comprising the state. So, I mean, there's some, and it lists out examples, and it's, and it goes down, talks about it's unlawful for any person to willfully, maliciously destroy, demolition, any memorial historic property, willfully, maliciously pull down a memorial historic property unless authorized by the owner of the memorial. And so it's back to the question, who owns it? Is it the city of Jacksonville owns it? Then it's all of us that owns it. And we all have a right to sit here and have an opinion in it. So let me get back here. You say in your opinion, and this is where it gets convoluted. On page 4, you know, you give the section 320-501A. The code states that before issue a permit, the building official examine or cause by the official may examine or cause to be examined by any building which the application has been received for permit to enlarge, alter, repair, move, demolish. All those are with commas, so they're all inclusive. And did the building official get involved in this process?
Through the chair to Mr. Gay, the building official was not consulted, is my understanding.
Okay. Well, I see that, you know, that's where I think it's going to be hard to, Mr. President, get through all this, because we've got to get more people involved in discussing the protocol that's taken place, because there's definitely, the building official should have been involved. The contractor went, you know, there's evidence that potentially there was some issues that took place with the contracting that shouldn't have taken place in the manner that done. The notice of commencement wasn't filed. You know, there's proper notice in place that cannot be circumvented. And so I just hope that maybe we can look for more, get some more information for some more people that should have been involved in this. So thank you.
Thank you, Mr. Gay.
President Salem, could I respond to and follow up on Mr. Howland's questions and question to Mr. Teal, because I believe there's some clarification needed, and I want to make sure that we're all on the same page with that process. If not, I'm happy to wait and take questions.
I've got 3 other people in the queue. I assure you, you'll get an opportunity.
Okay, thank you.
If they don't do it, I'll bring you back up.
Thank you.
Mr. Carlucci. Matt Carlucci.
Thank you, Council President. I want to thank you for the meeting, and I want to thank you for the fair way you're conducting the meeting. And the points that have been brought up, I think, have been very good. I want to say one thing here, though. The General Counsel, the administration, has shown quite a bit of contriteness here this morning, even to the extent of admitting they would have done something different. And I think we need to give credit for that kind of honesty, because it doesn't always happen. And I thought your line of questioning was very good, Council President. I have to tell you, these are all good people here. We're all good people here. And to throw around the words of abuse of power, legal yoga. Look, I remember when 4 council members met at a bar after a council meeting on June 28th of 2022. And a couple of my constituents were there and heard everything that was said, including comments on me. If I'd have been council president, I might would have had a council workshop on that. I'm just throwing it out there because some of the strong language is coming from somebody who was using that towards me and others in talking on issues and bragging about a lot of other things. Enough said on that. If Mr. Fackler and Ms. Bowling had dug their heels in and weren't willing to listen and weren't willing to say, hey, we're going to make this better, it'd be a different thing. But the contriteness, I think, is genuine. I like Mr. Gay's questions. I think those are important, and I know those come out of his natural concern of his background. I was on the council in 1992 when we took up the issue of the Springfield Historic District. And before I go to that, let me just say this. I did call Mr. Fackler and spent about 30 minutes with him on his position and how he came up with his opinion. And I walked away satisfied. Maybe the process should have been different. I think the sheriff's office should have been notified. So all of that, but they've been contrite on every one of those issues. But when he started showing me those points that would trigger a certificate of appropriateness, I can tell you it brought back to memory everything that happened in 1992, 1991, when then Councilmember Darling was trying to make that Springfield area a historic district. And the driving force, I'm not saying it doesn't include certain parks, ballast, whatever, but the driving force was what people could or couldn't do with their homes because Springfield was desperately trying to save the architectural history of that neighborhood because people were taking the top story porches and enclosing them and putting beds up there for people to sleep in. It was degrading such that we were losing our most historic neighborhood. I don't remember one time, and I was involved, I was all in the middle of it. I don't recall one time the monument, the park, any of that was spoken about. I do remember people who were against the district didn't want to be told what they could and couldn't do with their properties. But it passed, and it passed by a vote of that neighborhood. I called Planning Department to ask if the monument was listed as a contributing structure. Now, I spoke with Mr. Fackler about this, and he said it was listed in the application. Well, when Springfield neighborhood was putting that application together, they were including anything they could that would be of possible historic nature to strengthen their case And I would have done the same thing, and don't blame them for that. But I called planning department to ask if the statute was a contributing structure, and I was told no. Now, it may have been in the application, but it didn't make it to the ordinance code as a contributing structure. Those are two different things. An application is one thing to be reviewed, and then it was put into ordinance form. The monument was not listed as a contributing structure. So all of these certificates of appropriateness were aimed at altering, remodeling, restructuring buildings, the type of windows, what you could or couldn't eliminate. So I'm just trying to bring a little institutional knowledge and a little common sense to this. I make mistakes every day of my life. Am I going over my time? Because if I am, I'll stop. Okay. And my name is on the front of that building where I sell insurance from, and I manage people's risk. And if there's a problem, even that my team takes, it falls on me. I take responsibility. Everybody here that had a role in this has come up here and taken responsibility and been contrite. Should have done this, should have done that. So, look, there were some mistakes made. If you go back and you read history on Abraham Lincoln, and he did the Emancipation Proclamation, his own cabinet questioned whether he should have done that Emancipation Proclamation the way that he did. And he had many people challenge him on that. And one of the comments he made were, different lawyers, different opinions. Different attorneys, different opinions. So I'm not sure even the proclamation of emancipation was done correctly, but at the end of the day, I'm damn glad it passed through and it was done. As I look at this, and of course, some may say, well, you're prejudiced because your line of thought is you wanted the monuments removed. Well, I also want to say this. I put together, and I tried to comply with a process that this council put together on that. And I brought it up. Nobody wanted to say anything, so I started it out. Brenda Priestley barely got on the queue. She went her time, and the vote was called for, and it lost. Okay? That's what happens up here. And I don't think that was a fair hearing, considering the amount of months I had put into that issue. As the mistakes that perhaps the General Counsel made, not intentionally, he's a little new on the job, and any mistakes that the mayor's office made, they admitted to it. They bellied up to the bar and said, we'll do better next time. It's long past. This council had the opportunity to take leadership on this issue and never did. I gave us that opportunity, but nobody wanted to take up on it. I think that we need to put this, we need to get everything aired out. Mr. Gay's concerns, very legitimate. Your concerns, very legitimate. But I hope this does not get dragged out into calling people up, to abusing people with certain catch lines and political statements, because to me, some of us up here are wanting to address this in a meaningful way. Others up here are doing this in a political way, and I think it's making our process look bad. I think that everybody needs to say, we're going to make this better next time, And we need to put this behind us and move on, because this is doing nothing but stalemating our ability to move this city forward. Any other concerns expressed by the council that perhaps like Mr. Gay's that are legitimate or like yours? I think they can continue to be looked at. But I hope we don't get to the point where we're putting out subpoenas, we're calling people to take an oath. I don't want to go there.
Mr. Carlucci?
Good people can disagree, as you have said. So if I've used up all my time, I apologize. I know that you took a considerable amount of time, as did some others, and I wasn't counting myself, but I think we got a tempest in a teapot. Some mistakes were made. Let's not make them again, and let's move on and move the city forward. Thank you.
Thank you, Mr. Carlucci. I have 3 speakers for the first time, and I have some concluding comments I need to make, and I may bring up one other person. So I've got 3 speakers for the first time, and I think Mr. Boylan wants to say something as well. So I'm going to ask you to go no more than 10 minutes, which I think will give us ample time. And I've got Joe Carlucci next. Mr. Morrow, you're there.
Thank you, Mr. President. Seems like Councilmember Matt Carlucci just always beats me in the queue, so I guess that's just going to have to be how it is. And I agree with what my fellow colleague Matt Carlucci said, and I don't take it. I'm not trying to get personal on this. I'm not trying to do anything. I'm trying to do exactly what the mayor's office and we expect you to do: call balls and strikes. So again, I really want to zero in on just a question, because it seems like the second opinion or the second memo you sent out is extremely detailed. Specifically, on Section 2, questions presented, number 2, or B, letter B, it says, is the mayor prohibited by the code from contracting with a contractor to perform in-kind services, i.e. Confederate monument removal and transport from Springfield Park, where the Confederate monument removal is referenced in the CIP and the contractor performs the in-kind services at no cost to the city? That seems extremely detailed, which is fine. But first, just statement. I feel like I could change one word in that and it would just blow up the whole opinion, to be perfectly honest. Because you know as well as anyone, when you change just one little word in the question, it'll change the entire opinion. Would you tend to agree with that? Depending on the word, correct? Right? Yeah.
As I tell my 11-year-old and 9-year-old, words matter, and so you're absolutely correct.
So first of all, it's still, and I said this in the first one, it is kind of concerning that your draft opinion was like 2 sentences, and it basically just said the mayor has exclusive authority or absolute authority or whatever. I think we all kind of hashed that out, and you said, that was a little strong wording, and we went back and changed it. But they acted upon that, not this one. The result is still the same. So my question is, if you read this, so ultimately it says where the contractor can do this, where the Confederate monument removal is referenced in the CIP. It's referenced in the CIP. The contractor performs in-kind services. They performed in-kind service at no cost to the city. So my question is, how do you interpret at no cost to the city? How do you interpret that? Because there was a cost, just playing devil's advocate, calling balls and strikes, there was a cost incurred by the city, a small one, $902 for the security, whatever. I don't think anyone's going to get upset about that. But I'm just looking at the words here, and coming from an insurance agent, we like to hang on to these little small words when we ask for these clarifications, when we go ask for exceptions. So my question is, what's the definition at no cost to the city? Because everything else seems pretty literal in your interpretation. So how do you carve that out and interpret that for me to have ease that there was a cost to the city as a result from the services they performed? So I get that their services didn't cost anything to the city, so don't need to address that. But there were services performed that did result in a cost to the city.
And that's something that I was not aware of until this morning. I did not know that there was a cost to the city.
So, how can you? Okay, I get it. So that's just a question. I get it. So my question, that kind of just, do we need to now get a new opinion about this because there is a cost that was associated to the city?
I think we would need to make sure to look at the analysis and how that plays out. And off the top of my head, and I have learned from my mistake, is that I need to consult with my deputies and so forth to make sure that we,
right, and
the experts in GovOps, and make sure that we are right on that front.
Okay, yeah. And again, mistakes are made. I'm not trying to get on to anyone about making a mistake. I mean, we all make mistakes here. It's just frustrating because, again, we're all here because we want to understand the process. I think Council President wants to understand attorney-client privileges as well as I do. There's just a lot of questions. So I guess that kind of is a dead-end road for me until I get a new opinion from your office, if that's going to be presented, because there were costs to the city, and it's just, again, balls and strikes, right? Don't have any dog in the fight otherwise. Just want to see the questions presented in the most accurate way possible with the most accurate answer available. So that's really it. Are you going to, can I assume or ask that you're going to be working on that now that you just found out about that information?
If that's the request of the council, we can certainly look at that.
I think it's a worthwhile request. I mean, I don't necessarily want to have a whole nother, I mean, unless we need to, but I think that's the question to ask, not the question that's in the memo. The question in the memo is now irrelevant. The new question would be, take that out.
If a council member requests that you take a look at it, he's one of 19.
Absolutely.
I think you should look at it.
Okay.
And report back to him.
Yeah, that would be
He's
fine.
asking for it. You should report back to him, and if he deems the rest of us need to get engaged, I'll let the two of y'all work that out.
Okay. If you wouldn't mind, that'd be. Oh, Ms. Bowling? Yes, sir. Sure. Come on up.
Well,
I've got 4 more minutes. I'm happy to hear from Ms. Bowling.
Okay.
Thank you, Councilman Carlucci. Through the chair to Councilman Carlucci, I believe that we can get this sponsored. So we will go through the right process, look at the process, and get that $9,000 or $900 covered, if that helps.
So we'll get reimbursed? Is that what you're basically saying?
Yes. Okay.
Well, again, I wasn't worried about the $900. I was worried about just the opinion and the process in general. But if
understood.
So, Mr. Fackler, no, you don't need to come back up. You can take a rest for a second. Why don't y'all just discuss that, figure that out, and then Mr. Fackler, just get with me if you can, and just say, hey, this is what the administration figured out, and we'll go from there. Sound good?
Yep.
Okay. All right. Cool. Thank you, Mrs. Bowling. That's all, Mr. President.
Thank you, Mr. Carlucci. I go to Mr. Carrico.
Thank you, Mr. President. If I could bring the sheriff up real quick, I don't want us to gloss over the safety issue here and kind of some of the mistakes made, and I want to ask him a few questions. And it looked like it hurt to get up out of that seat. I'm sorry to have to bring you up again. You all right?
Yeah, the seat's low. I'm good.
All right. All right. Legislative Services, next time we have the sheriff, if we could get a high table, that'd be great. In your opinion, Sheriff, if you would have known about, the activities that were going to take place, knowing the sensitivity to it and the public, outcry on both sides of the issue, how many officers would you think would be a safe amount to be out there in that park that day with that activity going, based on what we've seen in some other cities?
Depending on the situation, it's hard to say, but what I can tell you is this, Councilman, through the chair, is in a situation like that, how I feel about the subject doesn't matter. The safety and security of this city, of the people in this city, is what's most important to me. In a situation like that, I would have gotten my executive staff, directors, much like when we had the event in front of the City Hall. We had bike units out there. We had people out there just in case. It takes nothing but just a small incident to create a major riot type situation. And don't want that on my watch, don't want that in the city. So in an event like that, we would have had, I believe in over-preparing. I believe in making sure that we have what's necessary, what's needed out there. And at the least, we would have had a bike unit, some officers out there to control traffic, and officers out there to make sure that if something does spark, Takes one in most cases. We could intervene immediately.
Yeah, that's kind of my concern on the what if. What if someone draws a gun? What if someone gets in a shoving match? And then our backup plan is to call 911 because the substation is 3 miles away. Don't fill in the blank on the what if, but I think we can all use our imagination to see how that could get out of control real fast and be a real tragedy. So that's all I wanted to clarify. We were told in this one of these hearings during the Rules Committee that the reason why the council members weren't notified was because it was a safety concern. And Ms. Bowling has apologized and said we could have done it better, but I just want to put it out there that the safety of the citizens were definitely jeopardized by not calling you, and that's disappointing to me. But I'll let you sit down or just stand if you want, so you don't have to get back up. Thanks for being here today. I know you have a busy day,
Thank
like
you,
always. One more question I have is actually for Ms. Taylor. You can answer from right there. You have a microphone. When you were talking about the improper purchases where you got the memo from procurement that had happened, is that a frequent occasion? Does that happen weekly, monthly, once in a blue moon in your experience? How often do you see those memos?
Through the president to Councilmember Carrico, it's difficult to answer because we had fallen off the list of apparently receiving them. So the last one that we received was 22, but I understand that there have been them, but they are an infrequent. We log them in our office when we get them, and we keep track and we review them when we do get them, but they are infrequent.
Okay, thank you. Just kind of going back on the mistakes, and I do appreciate Mr. Carlucci's point that there have been some apologies today and that people have owned up for their mistakes, but it's like asking for forgiveness instead of permission, right? When I was 14, I wanted to go out and play spin the bottle at some party down the road, and if I would have asked my mom to do that, she would have said no. So what did I do? I waited till she went to sleep. I climbed out my window. I played spin the bottle. It was a night of my life, and I got caught, and I got in trouble, and I asked for forgiveness. They forgave me. If I would have asked up front, I never would have went because I know, and it was don't do it. And it's kind of the situation. I think the administration knew what was going to happen if they lined it all up and asked permission and tried to dot all the I's and cross all the T's. Still might have got the correct result that they wanted at least, but we have processes and we didn't follow them. So due to those, I think the safety of our citizens was in jeopardy because of some of those mistakes. I think the trust of the OGC now has been breached because of those mistakes. We haven't really digested the Teal testimony, but it sounds like the Office of General Counsel folded due to political pressure from the mayor to come up with a decision that they wanted. And it's going to be hard to earn that trust back. We need leaders that look before they leap and don't just go out and do what they want and then come back and try to justify it. So that disappoints me. I just wanted to put those thoughts on the record. I don't have any more questions, sir. Thank you for the time.
Thank you. Mr. Romero. And then we're going to Mr. Arias, and then I'm going to bring up someone else and give Mr. Fackler a chance, and then I'm going to try to get some public comment.
Thank you, Mr. President. I need 2 minutes. I need Jason Teal. I think we've have some clarity as to the fact that processes did fail. Mr. Teal said something earlier in his testimony that caught my ear, and I just wanted some clarity on that. You simply said that the work did not meet the definition of demolition or alteration of a building, which is required for a COA. Can you clarify that for me, please?
Sure. Again, Jason Teal, Office of General Counsel, through the President, Councilmember Romero. So Chapter 307, the purpose of it is to preserve what's called historic fabric. And so, as Councilmember Carlucci mentioned, when you form a district, you identify everything that's in that district that's significant and leads to the significance of that district. And so they put in Chapter 307 contains a process so that property owners have a means to request the city review what they want to do with their property so that the city can say yes or no. You guys have seen appeals from some of those decisions. So what in terms of you can do to your property is, there's a definition in the ordinance code in Chapter 307 that says demolition means to paraphrase a little bit here, to remove in whole or in part I don't know if it's a structure or building. And so that is what's considered demolition. Now, an alteration is where you are replacing windows, for example, or you're re-roofing your building, or you're altering your property by putting up a fence, or affecting your driveway. You want to put brick pavers in instead of concrete. So there's a distinction between, the intent of a demolition is somehow you're doing something that's for all, accounts, is irreparable. You're making a permanent alteration to a structure itself. Well, bad word choice. You're making a permanent change to a structure itself. An alteration is that you're keeping the structure intact. You're just addressing like specific features within it. So I think that's the reason why the memo says that it's an alteration as opposed to a demolition, because it was the remainder of the structure is still there. It's just the statues were removed. Hopefully that answers your question.
Okay, I'm going to go to Mr. Arias, and then Mr. Boylan, then I'm going to conclude.
Thank you, Mr. President. I'm not sure who I'm going to direct my statements to, but it's just a general overview, okay? So nobody needs to stand up right now. The points that I'm going to make right now are not necessarily for whatever reason, a motive-driven reason. It's more about transparency. And one of the things that we've been actually focused this week at Council. So when we're talking about transparency, we're talking about keeping the citizens safe. Yeah, there were several of these citizens that were showing support on December 27th. Even one of our colleagues provided, whether it was donuts or coffee, whatever the case is, that was being done. So we're trying to keep the citizens safe, yet we're still promoting this. Whichever side you're on, it doesn't really matter to me. The transparency was not kept on that part. Going back to safety, JSO, knowing the magnitude of this, the sheriff's office, and particularly the sheriff, they were kept in the dark of this. So where was the transparency on this part? One young officer was there, not knowing what would actually transpire that day. They thought maybe it was just a construction issue. But you put the life of that officer in your hands. You made that call yourself. Yet you hired 4 or 5 private security representatives from, I'm not sure which company, but Ms. Bowling stated in that message that that's the reason why these private companies exist for this matter. So my question to you is, and maybe this is for the sheriff, if you don't mind, please coming up here. When you're talking about private security officers and JSO officers, are they trained in the same capacity? And are they trained to de-escalate situations should something happen in that case?
I can tell you that with the way we're trained to deal with public disturbance, whether it be a riot situation or large groups, there's extensive training. We train monthly on that, and I can tell you that a private security company will not have that training and is not capable of doing what we're capable of doing.
Exactly. Thank you for that, sir. You have a seat. So, I mean, you heard it. This is the expert, the ultimate expert when it comes to law and order, to safety. Yet, there was no transparency, no communications to JSO's office. So that just tells me that it was negligent on that part, number one. Number two, continuing with transparency, as we mentioned, this whole week we've been talking about transparency, and particularly one of these ordinances that I love is 2023-871, which I co-sponsored. And I'll get to that one in a second, but Councilman Gay mentioned the city owns the monuments. We own the structures. City of Jacksonville, meaning not just us council members, there's 19 of us, right? Some of them are not here today, I'm not sure why, but there's 19 of us. Not just the council members, but the citizens of Jacksonville also own these structures. Not the mayor, not the mayor's office, the city of Jacksonville. We all own the structures. Yet, nobody was made aware of this. It just happened overnight on the 27th. Where was the transparency on that part, right? So going back to Ordinance 2023-871, it's being perceived by some of our colleagues that this is just a political stunt. Nothing political about this. We are here trying to only make sure that the mayor and her office does what she ran on, which was transparency. That's it. That's all we want. That's why the citizens of Jacksonville elected us, to not only protect their rights, but also to make sure that everything's done accordingly, like Councilmember Gay said, law and order, done properly, protocols. When, sorry, one second. All right, so going back to now the mistakes, and I wanted to talk at the end because I just wanted to hear everything on. But when we're talking about mistakes, and yes, Mr. Carlucci, I understand that people make mistakes. I made mistakes. I still make mistakes these days. 100%. We all do. But ultimately, when we have important roles to fill, mistakes are not an option, right? And there's one thing making a mistake, and there's one thing to be completely negligent about things. Those are two different things, all right? As Councilmember Carrico stated, the trust has been broken. And in my opinion, the trust truly has been broken. Because now we have a general counsel that acted without our consult, without the sheriff's consult, and without, right, quite frankly, the citizens of Jacksonville. So once again, I don't have a dog in this fight. It is what it is. This already happened. But ultimately, what I want to make sure is that we uphold the transparency. There have already been 2 issues in the last 6 months that have caused transparency-related matters within the administration's office. One was the sole sourcing contract, and one is this. That's only 6 months. So the reason why we're acting the way we're acting right now, the reason why we're having these meetings are not just to bore whoever it is or to say that this is political stunt. No. These are one too many instances in 6 months. We need to make sure that we hold everybody accountable, and mistakes, in my book, are not okay. And that's all I have to say, sir. Thank you.
Thank you. Mr. Boylan, and then I will conclude.
Thank you, Mr. President. I'll try and be brief. First of all, and I apologize if this is a little self-serving, but I first of all want to let people know the reason I'm here today is because you called the meeting of the council. And I believe the importance of our responsibility of living up to that. I've served in this council for 4.5 years, or 4 years and 6 months. I have missed one council meeting because I had COVID. I've attended every standing committee meeting which either I led or participated in all the special committees as well. So, I take that responsibility very seriously. And the second reason I'm here is to hear the great questions and comments and concerns raised by my colleagues and the responses we learned both from the administration and the Office of General Counsel. Councilman Carlucci regularly references me as a process guy, and I really am a process guy. I think I've demonstrated that time and time again in some of the work that we've done together. So I am particularly concerned about the process and making sure that the steps are clear and precise in moving forward. I wanted to go last because I wanted to make a suggestion, particularly as it relates to my new council members. When we had this whole JEA situation almost 4 years ago now, we took one path and then a second path. My ears perked up when I saw in the paper this morning the Special Investigative Committee referenced. The first path we took as a council was to take at the SIC process, which I was involved with in both iterations. The other was the creation of the future of the JEA process, which allowed us over the course of a year to take a hard look at Article 21 of the Charter to make certain that transparency, accountability, governance responsibilities, all those things that were laid fallow through the process of JEA happening. If we decide to go down a path, and I do appreciate the fact that you already have a bill looking to address some of that. And Mr. Fackler also mentioned he has interest in taking additional looks at that and making some additional content to it. Perhaps we should elongate that a little bit more to make certain we don't have this kind of situation in the future. There's no question, we all agree, malicious or otherwise, and I don't believe that they were, mistakes were made through this process. Let's make sure that we have a clear path going forward. We all lament the fact that this is surrounding the removal of the statute. We wish it were something else that, frankly, this came about, and Councilman Howland pointed that out as well. I would ask that if we do decide to move forward with this, we do it from the context of saying, how do we make sure this doesn't happen again? And without pointing fingers, we all understand and we made very clear through this meeting and prior ones that the mistakes were made and that we should move in that direction. I would rather see us more focused on the future than the past and make certain that we don't see this happen again and that we and all of us can focus on our time and on the energies that our constituents are asking us to do. So thank you, Mr. President, for the opportunity to share that.
Thank you, Councilmember Boylan. Mary Stafford, can you come up front, please? I want to give Mary a chance to answer a couple of questions. Then I'm going to turn to Mr. Fackler, and then hopefully we can get some public comments. Thank you. You want to just identify yourself for the...
Mary Stefopoulos, Office of General Counsel.
Mary, I understand that you were not in that Wednesday powwow meeting of all the deputies and such, as I understand it.
Yes, Mr. President, that's correct.
But I understand that you had a discussion with Mr. Fackler after that meeting when you understood, and I don't want to put words in your mouth, but you understood that the opinion was changing and you went and saw Mr. Fackler.
Yes, I attended the UF Health audit meeting that morning, so I was unable to attend the meeting with the other deputies and Mr. Fackler. I did stop into his office that afternoon just to check in because I had missed that meeting. And my understanding from Mr. Teal prior to that, my stepping in to meet with Mr. Fackler, was that the discussion was that the memo would change to reflect that there was a COA required, but that Mr. Fackler did reserve the right to continue looking at that issue and revisit it if he so chose. So when I went to Mr. Fackler's office, it was simply just to follow up after my absence from the earlier meeting and to just discuss kind of how would you approach, if the memo changed, how would you approach the fact that it's changed and it's such a public issue? And we just talked briefly about that.
Strategy on how he should handle that situation with the opinion changing and who he should talk to and how he should handle that.
Yes, I think he and I have talked on several occasions just in general, recognizing that what we do is important but very public work with the city, and just how do I approach different things in my role, and how would I approach what was going on with the memo if it were to change, but recognizing that it may not have changed. So it was just a brief conversation.
Thank you. Mr. Fackler, if you would come forward, and I just want to make a couple of comments before you speak. I recognize on multiple occasions you have said, if I could do this over again, particularly on the draft and only including yourself and those things. I recognize those. I know Mr. Carlucci has alluded to that. I don't feel that same way from the administration. What I feel from the administration is a hammer and a nail, frankly. But I recognize from your standpoint, I think you have learned a great deal from this process. I think it's just tragic that you were put in that position a week after you were confirmed. I think that was just the wrong thing to do for you. No one should have put you in that position. And I think it caused you to make some, mistakes, frankly. But it's good that I think you're realizing them, and I think I will work with you on my bill, and I want to move forward. I think we pretty much know exactly what happened in this situation, but want to give you a couple minutes to say what you want.
And thank you, President Salem. I want to say that I am committed to working and building back that trust. I know Councilman Arias said that it was breached. I am doing my best to call balls and strikes. I had hubris, perhaps, in thinking that I could do it by myself. It was not at the request of the mayor. It was my honest attempt to call balls and strikes. The way I did it, initially, I relied on something in the bill summary that was just wrong, and it was more than that. So the conversation with my team elucidated that I was more than what I initially reached. And then I had several sleepless nights thinking that I had provided the mayor with incorrect advice. And going back to something that Mr. Howland asked that I wanted to get back to, so I appreciate the time, the conversations on that Friday were questions about whether I had any discussions with the mayor. I didn't come up, or I didn't think about it at a meeting on Thursday afternoon Before that Friday, I had a meeting with Karen Bowling and Kelly O'Leary, at which I said, I'm concerned, based on this new information, I'm still digesting it, that my opinion might change. And it wasn't so much that I was concerned about agreeing with the mayor, it's that I had provided her with legal advice that I was concerned now was wrong. And that would have been a horrible conversation for me. And so that's when we retrenched, so to speak. I worked with Mr. Teal, and the advice didn't change, but the method changed. And so I apologize if I misanswered the questions about how that process went down. I had forgotten about that Thursday afternoon meeting and my subsequent conversation. It was not, I don't want to have I want to make sure the mayor is happy. It's my reputation. I've given bad advice on such an important issue, and you can imagine that Thursday night and Wednesday night was extremely stressful going through that process and doing that additional research. So I appreciate the opportunity to revisit that, and I hope that answers more of your question of how the process worked. I didn't want to leave the impression that I misspoke, and I think I did.
The only comment I would make to that, Mr. Fackler, if we could have come to that conclusion that maybe things changed 2 weeks ago, we would not be sitting here today. I mean, I gave you, clearly I knew something was wrong when you're asking me for extensions on time to develop an opinion that you already made. I mean, I'm not a lawyer, but I do work with deadlines, and I have for 45 years, and if someone asks for multiple deadlines, there's a problem.
Understood.
There's a problem, and I thought very kind to you to continue to give these extensions, but it is lengthen this period of time post the monument coming down. I don't think it's the council's fault. I mean, when we got the opinion 45 minutes before that Rules Committee meeting, I had several council members, unfortunately, that are not here today, that came to me and said, we want another bite at the apple because we haven't had a chance to read it. For some reason, they decided not to come today. I can't speak for them, but it's very frustrating to me. But it would be my goal with what you've said to try to move this process forward. And you're the General Counsel, so we need to be able to work together. But I'd be lying to you if I hadn't lost some trust.
And understood, Councilman, and Councilman Arias mentioned that as well. And I will commit to working and doing my best to earn that trust back.
And I've given you some suggestions.
You have, and I'm taking them to heart.
Okay, I'm not out here just. I've given you concrete suggestions that I think would help you rebuild that trust. You've got to hopefully evaluate them, and I hope use them. Okay?
Yes, Councilman.
Thank you. I'm going to go to public comment. I have how many cards? 6, did you say? 6 cards? 7 cards. Let's go with a minute and a half. Rick Robinson. I think it's Costa Rich, DL, Rick Robinson. Is he here? I'm sorry. I apologize. I didn't see you stand up. Okay. All right.
As was correctly observed, I am Costric DL Rick Robinson. I reside at 1949 Hubbard Street in Jacksonville. I'm speaking both for myself and for the Northside Coalition. Listening to this morning has been very distressing because we're here because the council failed to act. More than one mayor has wanted to do something about these monuments. We have been here time and again asking for something to be done. In the future, if the council could be more responsive to all of us in front of the podium instead of those behind the podium, we wouldn't be in this kind of situation today. And that's all I have to say. I appreciate having had the time to say it. You folks have a great day.
Thank you, Mr. Robinson. I have John Reynolds. John Reynolds? Sir, you've got a minute and a half once you come up to the podium.
Okay, good morning, everyone. President Salem and council members. First time I've been here, so if I happen to do something and err, my apologies ahead of time. Well, I've kind of been following along with this, and first of all, I want to tell you, I'm a retired city employee. So many of these procedures of purchasing and things that I have been familiar with and had to abide by. And I'm deeply concerned that the actions that came out of the mayor's office and that this situation was a sole source award and it was not a competitive bid. That concerns me, and I've been reading through the ordinance codes, and of course I get lost in that pretty quick. But anyway, a lot of things to comment about. I don't have questions, but I think that what I see that was an act of deliberance to avoid the input from the community and so on and so forth. And I'm quickly running out of time here. So anyway, I guess I'm just not going to have enough time to make all of my comments. I'm sorry, but I did write a letter to you, sir, and also Councilman Howland. I sent you both an email outlining some of my comments, but I'd be happy to speak to you again.
Thank you, sir.
Thank you, sir.
We appreciate you coming forward. Pat Gear.
Hello, Pat Gear, 6036 Park Street. Mr. President, thank you for having us. Just a couple of comments. I was troubled by the last Rules Committee meeting when Mr. Fackler referred to the mayor as his client. I thought the General Counsel's office, y'all were his clients as well. And by default, you're my client. I mean, I'm a client of yours, so you're a client of the General Counsel. So that's really troubling. I think one of the other issues I had was Mr. Joseph was aware of the statue removal. There was a city councilman there when I showed up that morning and saw the coffee and donuts for the crews that were there, the participants, who happened to know that it was going on. The sheriff wasn't notified, and you weren't notified, sir. I was there because I went up the night before to tell that something was going on. One thing that the sheriff mentioned, I'm sorry he's not here, but when I was there, I was armed, just in case. So I do carry. The other thing, this has just shown such discredit to the city and the council's office, and it also, the mayor, is just ridiculous, and it's going to be hard to repair that. And I don't like the fact that the other attorneys basically got thrown under the bus with this. Thank you, and I would like those statues replaced, put back into place.
Thank you, Mr. Gear. Denise Scoffed.
Oh, good morning. I'm a little disappointed that we're still here wasting time about the monuments. The whole council had an opportunity to act, but you chose to not even want to discuss it, and the people have made the decision that we want it down. White privilege is invisible to those who have it. White males in America have always had privilege, and you've started that when you've taken down, when you started with Native Americans, with slavery, with Jim Crow, and these monuments, you all know what they stand for, and we don't want them here. This is the 21st century. Can we move past this? How How many workshops are we going to have about this? We're spending all this time complaining about the process, but nobody wanted to talk about getting them down. You had the opportunity to bring it before us. Nobody wanted to talk about it. We come up here, council meeting after council meeting, talking about it, what they represent. You know what they represent. They represent white supremacy. They represent the KKK. The Daughters of the American Revolution, they spent that money to get them up there when they erected it in 1912. 1915, it was completed. Why? Because people, my ancestors, they wanted to intimidate them. You all know that. Let's stop complaining about why the process was there, and let's move forward so we don't have to worry about that anymore. I appreciate it. Thank you. Sir? Oh, I'm sorry. It's Denise Scott, and my address is on file.
Kate Dobbins.
Hello, my name is Kate Dobbins. My address is on file, and I'm a member of Take 'em Down Jacks. I just want to point out the particular ridiculousness of some of the comments from some of our city council members. We have a jazz festival every year, and it's scheduled again for this coming Memorial Weekend, that thousands of people attend, and the decision makers in this city don't even care enough about safety and security to mandate that attendees pass through metal detectors for admission. And only one council member today even broached the subject of Jacksonville now being on the right side of history. We have made international headlines for all the wrong reasons for many, many years. The last big one being the shooting at the Dollar General store in August. Leaving up these monuments to hate and oppression only enables and emboldens these racist white supremacists. The Pentagon has changed the names of the bases. Richmond, the capital of the Confederacy, took down all their monuments before we did. The majority of the city council members just sat on their duffs, abdicating your responsibility of leadership. The mayor just wanted to do the right and moral thing. She made her best effort to attempt to properly dot the I's and cross all the T's, but you are still not satisfied? Shame on you, members, for supporting and or pushing this dog and pony show. I was recently out of town spending some time up in Tennessee, seeing Confederate flags and emblems, but to finally cross over the Florida border for the first time to return to my adopted city of Jacksonville, knowing we no longer have these monuments to hate and oppression. Thank you.
Thank you, Ms. Dobbins. Joanne Brooks. And our last card is Seaber Newsom.
Good morning. My name is Joanne Brooks. My address is on file. I'm a proud member of the North Side Coalition of Jacksonville. The North Side Coalition continues to support the mayor's removal of the Confederate monument in what we call Ben Fraser Park, and the initiation of comprehensive community-wide meetings called charrettes, a process also supported by the Jacksonville Civic Council to discuss the removal of all monuments, markers, symbols, and names that glorify Confederacy, racism, discrimination, segregation, and all forms of oppression. I think it's a shame that we believe that we needed so much safety and protection when we had a peaceful removal of that Confederate monument. I think that this council should reconsider some of your hearts, your dark hearts up here, and consider doing the things that represent this community the best way possible. We appreciate your work, but we also wish that and pray that you would stick to some of the things that would glorify God. Thank you.
Thank you, Ms. Brooks. And the last speaker is Seaber Newsom.
Hello, my name is Seaber Newsom III, and my address is on file. The city does not own the monument. The state of Florida paid $12,500. The United Confederate Veterans, which is now the Sons of Confederate Veterans, paid $12,500. There is no deed given it to the city. If so, I want to see it. I got proof of what I'm saying. Call Joel McKeeshan. He used to be in charge of the Historical Preservation Commission for decades. He retired a few years ago. He told me in 2015 in person, because I wanted to make Hemming Park a designated city landmark. And I mentioned Confederate Park. He said, you don't have to. It's protected. It's in a historical district. He knows more about city than anybody. Put the statues back up. You cannot just remove an historical structure from a historical district and then say, oh, well, it's gone. There's nothing we can do about it now. She broke the law, the rules. If you don't follow the rules, you don't have no law. Why even have a historical preservation commission if you won't abide by their rules? And the city did take action on this. The city council voted 13-6 not to remove them. I was here. So all these people saying, well, the city did, y'all didn't want to do nothing. You did do something. You didn't vote to take them down. Put them back up.
Thank you, Mr. Newsom. We are adjourned.